Neil Coughlan against Minister for the Cabinet Office.
Your Lordships, Your Ladyship, I appear on behalf of the appellant Neil Coughlan, along with my learned friends Sarah Sackman and Natasha Simonson. And the Minister for the Cabinet Office is represented by my learned friends Mr. Giovanetti of Leading Counsel, Hanif Musa and Emily Mackenzie. The first, second and third interveners, who are the Runnymede Trust, Operation Black Vote and Voice Change for England, have submitted a written case prepared by my learned friends Matthew Ryder of Leading Counsel, Ayesha Christie, Gayatri Sarathi and Michael Etienne. The fourth and fifth interveners, the LGBT Foundation and Stonewall, have submitted a written case prepared by my learned friends Timothy Ottey of Leading Counsel and George Molyneux. This is an appeal from a decision of the Court of Appeal dismissing an appeal from a decision of Mr. Justice Upperstone dated the 30th of March 2019, whereby the learned judge granted permission to apply for judicial review but then dismissed it. The application was for a quashing order or declaration of unlawfulness in relation to a decision of the Minister dated the 3rd of November 2019, whereby she decided to make orders pursuant to Section 10.1 of the Representation of the People's Act 2000 for the operation of pilot schemes in Braintree and 9 other local authority elections. These pilots imposed on voters a requirement to produce identification papers as a precondition to being permitted to vote. My lords, my lady, no right is more precious in a free country than that of having a voice in the election of those who make the laws under which we as good citizens must live. Other rights, even the most basic, are illusory if the right to vote is undermined. So ruled the Fourth Circuit of the US Courts of Appeal in the case of North Carolina and McCrory, striking down the state's requirement of voting identification as unconstitutional. The US Supreme Court refused to entertain an appeal against that ruling. Thus, my lords, my lady, say the American justices in their Supreme Court. The right to vote is no less precious in ours. This Supreme Court has made clear in Muhan's case that the right to vote is a basic constitutional right for us too. Even though we have no written constitution, it's beyond argument that we have constitutional norms and constitutional rights. And the right of unrestricted access to the ballot for those registered to vote must be, we submit, one of them. In this country, since at least the Ballot Act of 1872, 150 years ago, no one has had to produce documents at the ballot station as a precondition to being given a ballot. Documents which the voter might find difficult or practically impossible to produce. And no one's right to a ballot has been conditional upon their being able to prove beyond reasonable doubt their identification and their right to vote. No one has had their right to a ballot subjected to the unreviewable subjective judgment of the officer on the spot as to whether he or she has a reasonable doubt, a judgment which may be capricious or prejudiced. The rules in force since the Ballot Act of 1872 have protected the citizen from such obstacles or potential abuses with the utmost stringency. Officers are absolutely prohibited from questioning voters beyond 2 prescribed questions, asking for a confirmation of name or address. They are absolutely prohibited from preventing someone from voting if they suspect they're personating. They even have no right to stop them from voting if the person is being arrested on the spot there and then within the polling station for personation. These pilots, therefore, represent a radical shift in our electoral landscape, imposing new eligibility requirements and giving unelected, unqualified, non-judicial officers de facto uncontrollable power to turn away a voter. The Minister claims that so great a power of dominion has been conferred by Parliament. He relies for his power on the words of an act, which makes no mention of changing the franchise, which makes no mention of imposing a new documentary qualification, and which makes no mention of giving uncontrollable powers of exclusion to clerks on the desk, and which says nothing about putting the onus on voters to prove their right to vote beyond reasonable doubt. My lords, my lady, this right to vote is something about which the appellant, who is here with us today, cares deeply. Mr. Coughlan lives in a deprived estate in Essex. As he explains in his witness statements, he's an active member of his local community. He's done community work in advocacy. He has previously been for several years an elected member of the local government. He also suffers from a disability and has travelled a long way in some considerable discomfort to be here. It will be clear to the court from his two witness statements that Mr. Coughlan is a man who, in the course of his working life, has tried very hard to do his best for those worse off than himself. He believes in local government, and he believes that the right to vote in local government is a right which this court should acknowledge and protect. Mr. Coughlan brought this claim in January 2019 because of his concern that the proposal in Braintree and 9 other pilot districts requiring identity documents to be produced would deter and disenfranchise many voters. He was especially concerned it would hit hardest people who are already marginalised, already less likely to vote. That is, those whose electoral voices the system needs to work hardest to make heard. As the appellant explains in his written case, to some extent, those fears have been proved to be well-founded. But, my lords, my lady, this is not a case about the merits of introducing an identification requirement. It's not about a criticism of the minister's decision, impugning it for irrationality or unreasonableness or any Wednesbury ground. This case raises a pure point of law. It's a pure technical point of law. In that sense, it is not a political case. It doesn't involve criticising the decision-making process of a minister. It's simply on the construction of Section 10 of the Representation of People Act 2000. The question is, did it authorise the minister to bring about so great a change? If not, then, my lords and my lady, Parliament has been usurped and the pilots must be quashed. I'll come to the words of the section later, but in essence, Section 10 empowered the minister to make changes in legislation and the rules under it concerning voting, when, and the words were, as to when, where and how voting at the election is to take place. And the election in question being a piloted election at which the changes will be tried out. We say that these words, by their ordinary and natural meaning, mean that the minister can change the time or the place at which voting happens, and also can also change the means by which the act of communicating a choice of candidate is communicated to the enumerator. Lord, submissions will be in the following areas. First of all, I'll be pointing out the 4 errors that we submit were made by the Court of Appeal. And then after that, there'll be 4 submissions on the construction of the provision. The first dealing with the principle of legality, the constitutional principle. The second, closely related, being the Henry VIII principle. Thirdly, then the semantics, actually, of the construction of the provision in question. And lastly, if there's any doubt about that, how it should be construed in accordance with its purpose. So, my Lord, we submit there were 4 errors in the Court of Appeal. Firstly, there was the semantic error. It's there, Mr. Justice Supperstone in the Administrative Court held that the power to change the statutes and regulations that must have a wide meaning, that where and when and how must have a wide meaning. And the reason was that he thought that the purpose was to permit pilots really of any change in the voting landscape. The Court of Appeal essentially upheld Mr. Justice's judgment for the same reasons. There, Mr. Justice Supperstone's words were, the Section 10(1) power was intended to allow proposed changes to local government electoral procedures from time to time existing to be tested. That being a very, very wide interpretation, which the Court of Appeal approved. The Court of Appeal themselves held, at paragraph 36 of their judgment, that the words were, I quote, quite general and were not restricted to physical methods of communicating voting intention. Our submission is that's far too wide, because that could include, on that interpretation, anything in the registration procedures which would be outside where, when or how voting takes place, such as changes to the laws about secrecy or changes to the laws about registration. Lord Justice McComb said the words were equivalent to asking oneself the question in relation to the meaning of the word how do I vote? And our submission is that puts the question too widely. That how do I vote could involve, well, first of all, you go along to the registration officer, you register to vote, etc. So it goes back too far. It's too wide. But Lord Justice Underhill, with whom Lord Justice agreed, said that Mr. Coughlan's construction was I quote, a very possible one, and the matter was finely balanced. So we submit this construction is wrong, and that the words how voting is to take place, by its ordinary or natural meaning, only authorises changes in the method or means of communicating a vote, the act of voting itself, and that the minister's power is so circumscribed. Secondly, there's the...
Mr. Peter, I don't want to take you out of your course, but as you've described the reasoning of the courts below, they formed a view of the purpose of the legislative provision and, if you like, read the language and gave it a register in the light of that purpose. And I just wonder whether that actually is the sort of logical order in which to take things. As I say, I'm not inviting you to change the course of your submissions, but do you have anything to say about that?
To answer that question immediately, my Lord, it's true. They found that the purpose was not just to increase voter turnout and make voting easier, which is our submission is that that is the purpose of these pilots. What they said was that they accepted that that was the most immediate prompt for the legislation. We say that we submit that it's clear from all the background papers and the Act, looking at the words within the Act, that the purpose was to make voting easier, facilitate voting, encourage it, increase turnout. Nothing at all about fraud prevention. Nothing at all that was designed to decrease or would have the inevitable impact of decreasing. But what the Court of Appeal said at paragraph 58 was that the purpose of the pilots was, and I quote, the modernisation of the system and its integrity. There, we say that's far too vague, it's far too wide, it doesn't focus on actually what either the words of section 10.1 say or indeed what the explanatory notes and also the other background admissible papers say. And in particular, because there's nothing which says that you can just impose a new condition upon the existing regime, which is the existing regime of voting by ballot at a postal station, at a ballot station, that you could simply impose ID for the purpose of fraud prevention, if indeed there is a fraud problem. And that everything was focused, in fact, on new voting methods, new times and places to try and widen access. So, of course, having found that purpose, it's true, my Lord, that then that informed the way in which they interpreted the word how. That's true. But our submission is that, I'll come to that later, is by looking at the materials, one finds that that's not the purpose.
Yes.
Mr. Speaker, can we just go back to how you defined what's meant by how? You said only authorises changes in method or means of communicating the act of voting. Can you just repeat what you said?
Yeah, yes, the word, I mean, how voting is to take, at the elections is to take place. The dictionary definition by the OED is that how means by what manner or means. Voting, we say, means the act of the voter communicating his or her choice of candidate to the enumerator. That's what's taking place. So we put those definitions together. These are the ordinary words we would submit. We have a very, very straightforward point of construction, which how is, so how voting means by what means or method the voter communicates their choice of candidate. If we say that that is the most straightforward.
Wouldn't the words by what means be wide enough to encompass you produce your ID?
That wouldn't be, except that's not, that doesn't then go with the means by which one communicates one's choice of candidate. So it's not the actual voting itself, it's before you do the act of voting, it's a precondition. Those words are also informed by the context of where and when. It's all referring to the same act, which is the act of voting, the communication of the choice of candidate. So it's an event, as it were, just a simultaneous, it's a single event. There's a place for it, where, there's a time for it, when, and there's the means by which you do it, which is the communication of the vote.
But why aren't the when and the where sort of the pre-stages to communicating your vote? Not quite sure that actually helps you.
Well, if one's focusing on the act of voting, whether it could be putting the cross on the ballot and putting it in the box as we do now, or pressing a button on a computer remotely or whatever it's going to be, or telephoning. That's an event in history which has to take place at a certain time or place, that one event. So it helps me in the sense it's focusing on that event, that particular act. So in context there, you're saying, well, what's the means of voting? Cross on ballot or pressing a button. Where? Could be at the ballot station, it could be in a mobile truck or something. When? Well, it could be at more days than just the one. It's when you do it. So these are focusing really, it's focusing on the actual act itself rather than what you do when you lead up to it. Like, do I have to go and register? And
well, that's what I was just pressing you on. I mean, isn't the when and the where people need to go to a particular place or how they need to act at a particular time, and the when tells them when to do it? I mean, those seem to be addressing, informing the voter, things that they will do before they get to the ultimate act of indicating to the counter what their choice is.
Well, this is, your Lord's approach is looking at it rather like the Lord Justice McComb of how do I vote question.
Yeah, I mean, I'm seeking to test why, yes. why should we read how as narrowly as you say rather than more widely? You were saying, just making a submission, that you get support from the juxtaposition with when and where, and I was just questioning that because when and where are addressing the stage prior to the stage you say that the how is focusing on.
Well, no, my submission is it actually addresses only the one event, which is the act of voting.
Okay.
And the act of voting has to happen at a certain time, in a certain place, and by a certain means. That seems to be the natural construction of the words. We say that...
Can I just ask you something on that? So if you look at the Court of Appeal analysis, and there's a sentence posited by Lord Justice McComb in relation to this, he, in looking at the definition of how, also refers to it as the how of casting a vote, firstly. I think you'd probably agree with that. That's
yes.
Part of your method. But also a lawful vote. Is that not something that's permissible to come within the definition of how? That the vote cast has to be a lawful vote?
Indeed it does, Benedi,
and the point therefore from that is, does voter ID not come within the definition of a lawful vote? In other words, there's a validation of identity to make sure the vote is lawful.
Well, I suppose the answer to that is that, I mean, that certainly was something which Lord Justice McComb mentioned in the context, I think, of what the purpose was.
Yes.
And I think it was saying, well, the purpose is only to encourage lawful voting,
yes.
which is a point taken up by the Minister. I think we say that's a sign of sleight of hand, because you encourage voting, because voting is encouraged by the present regime of voting, in the sense that it's made easy that you can turn up, confirm your name and address if asked. The purpose of these pilots is to improve that position. You're supposed to have a pilot which is meant to make it better, to have greater access, to make lawful voting easier. Now, at the moment, lawful voting is extremely easy, or as easy as the regime gives it. Question is whether, by requiring people to produce documents, you make lawful voting easier. No, you don't. You make lawful voting harder.
But voting has to be lawful, I think, Mr. Pito.
Oh, of course it does. But the question is whether, in fact, the purpose of this section is to facilitate or make easier, or to encourage. Yes, lawful voting. But the question is, will your change, the purpose of having a change here, is to make things easier or facilitate, yes, easier lawful voting, easier facilitation, all those things. But actually it doesn't, because honest voters find themselves now with an impediment, and some, as I'll come on to later, a fatal one. They can't actually vote.
Yeah.
And so, in fact, the answer is it's a play of words, really, because it's a way of getting in, by almost like a kind of a verbal sleight of hand, the idea that somehow it's a purpose here in this legislation to bring in new measures that don't change the method of voting, but which are designed to prevent fraud. I mean, one can look at it like this. These pilots, did they change the means by which one actually communicates a vote? No. There's nothing there at all. The means of communicating the vote, no change at all. You still go along, still the cross on the ballot paper. So we would submit that the minister didn't even come within the threshold of the power, because the power is only limited to making a change about the time or the place, or the method of communicating a vote. All the minister's done in these pilots is not to change that at all, but impose an entirely external requirement. Simply impose a new requirement, which is you have to produce certain documents before you can vote. And that doesn't get you into the how. The how stays the same. And in fact, Parliament tied the powers, we say, very directly to the when, where, and how. It wasn't a general right to change anything in the voting landscape, like how you register or the secrecy of the ballot, which would be the logical conclusion of the way in which the Court of Appeal and Mr. Justice Hupperstone, the way that their words were wide. This was tied to experimenting with ways of being able to increase the access to the ballot by having more time or more places or different and better methods of communicating the vote. If the minister gets through the door trying out, say, a remote voting scheme, then, of course, once he's through the door and has got a pilot which is therefore a change in when, where, or how, of course you might then have to bring in a different ID checking requirement as a part of it. One of the arguments by the minister is that because I have to concede that, it means that somehow I've conceded that there can be a standalone introduction of an obstacle to the existing ballot, which doesn't change the how.
I don't quite follow that argument. You have a how must encompass voter ID in relation to internet voting, for instance. But you say it doesn't encompass voter ID in traditional voting.
That's right, Neil. It goes like this. This is not a trivial submission or point. The point is that the idea behind the purpose of this legislation and the words of Section 10 speak of facilitating voting, making voting easier, providing facilities for the voter that they'll find easy to use.
I'm sorry for interrupting, but then does how have a different meaning when you have a new method being introduced that facilitates, but a restricted meaning when it applies to the traditional method of voting?
Well, what we'd say is it's not a restricted meaning, it's simply the way in which it's the OED definition, so therefore the most straightforward one. It's a change in the means by which the voter communicates his voting intention to the counter.
Yeah.
It's the means or the method by which. So...
But I mean, if I just develop the point, the way you're putting it, putting an X on a piece of paper opposite the name of your preferred candidate is I think, how you're presenting how.
Yes.
And you gave the example of an alternative being to press a button on a computer. But the legislation couldn't simply say press a button on a computer. It would have to include
a way of someone knowing who's voting.
Exactly.
Yes. Well, I absolutely agree with that. Yes. But this is really the point. Everything points to the minister being empowered to try a new way, to try a substitute of the X on the ballot paper and trying a different way of communicating, like pressing a button on a remote computer. But then if the minister's brought that in, that comes within the how. There's a change in the method of voting. Then, of course, you can't anymore have the system of simply telling the officer face-to-face what your name is. Then, of course, you've got to have a way of keying in a code or some form of remote identification which is different. But that is incidental, a necessary incidental implication about changing the means by which the voter communicates the vote.
It's still encompassed within the word how.
It is, but if we have what we had in these pilots, There's been no change in the how, my lord. The means of communicating has remained the same, my lord.
You say it comes in by necessary implication in
Yes.
that case. Why do you need to go that far? And why not read how? Some might say straightforwardly to cover verification in such a case, but then that might create difficulties for you on the argument that you are presenting.
Well,
why does one have to resort to implication?
it's not really, I mean, my lord, I suppose it's not implication in the sense it's just... it's just a necessary incident, as a matter of common sense, that clearly if you're going to be voting at home on the telephone or something, or by pressing a button, that you have to show you who you are by doing that. There's a question of showing who you are. But also, I've been diverted into the semantic argument, but I'd like to come to the constitutional argument.
I'm sorry, just before we leave the semantic point, can we take it that the fact that it's a secret ballot, that you go into a booth where you can't be overlooked when you're making your cross, and you then put the paper into a container which can't be seen into, are those all part of, in other words, the process is secret, is confidential to the voter? Is that all part of a how?
Well, the secrecy provisions are separate from the provisions about the ballot and how one puts it into the box. So the bits about having to have a booth, the bits about the officer not being able to, since the conditions are no one can oversee the vote, those are different provisions. Those are not part of the how, because it's not the means by which one, no, they're not. We also outlined these were the 4 errors we said that the Court of Appeal made. The purpose error I've dealt with as well. They also then ducked the question as to whether this was a constitution, whether voting in local elections was a constitutional right.
And I don't want to divert you from that, but at some time, will you actually show us the pre-existing statutory provisions that have been modified? Yes, okay.
No, absolutely. So what I'm intending to do, I've dealt very briefly with the errors. So there's 4 other submissions. The first one is what I might call the principle of legality submission, which is that it's a constitutional right, therefore attracts the principle of legality. Secondly, closely related to the Henry VIII principle. Semantics, which I've dealt with largely anyway, and then purpose, because, so as regards the submissions about the principle of legality, they divide into 5 sub-submissions, my lords. First of all, is the right of people on the court register to vote in local elections a fundamental or constitutional right within the meaning of what Lord Hoffman said in Sim's case? And we submit it is. Secondly, if it is such a fundamental right, then what is the degree of clarity which is required in legislation in order to authorise a restriction upon that right? And we'll submit that the words were crystal clear, or the words have to be such that the meaning has not gone unnoticed in the democratic process by Parliament. Thirdly, and this is the bit that you were asking about, my lord, is looking at the right to vote as it stands now, which is under Section 2.1 of the 1983 Act, and also the rules about what happens when you actually get a ballot. Then comparing those with the pilots to see how they've changed. And then looking at Section 10, which is the enabling, or the allegedly enabling act, to see whether or not they've authorised the changes. And also looking at the same time as the background materials to see whether Section 10 and the background materials meet that test of clarity. And fourthly, what level of interference with such a right by the executive engages the principle of legality. We'll be saying the test is whether the order impedes or hinders the exercise of the right. And it's not necessary to demonstrate that the exercise of the right becomes impossible. We'll be relying there upon my Lord's judgment in the Unison case. Fifthly, on the material before the court, is it clear, is there a risk that some people will be hindered or impeded from exercising that right? And we say the evidence shows that it's obvious that many will be. So first of all, the first part is this a constitutional right? It's widely accepted that despite the fact we don't have a written constitution, that we do have some rights which are regarded as constitutional. And for example, it's well established that access to the courts is a constitutional right from a line of cases from Honey's case, to the Unison case. That's well established. It's not just a right of access to the common law courts, but in the Unison, it extended to statutory tribunals as well. It's equally uncontroversial in our submission that the right to vote in parliamentary elections is a constitutional right. One sees that in Muhan and the Lord Advocate, in the authorities bundle, tab 4, where this court held it was a basic constitutional right and held the House of Lords had so decided in Watkins' case, where Lord Hodge said that for centuries the right's been derived from statute. Parliament controls the modalities of the expression. Lord Watkins said that it was a fundamental, basic or constitutional right, and that the principle of legality would apply in construing any statute provision which was said to have abrogated that right, because the substance of the rule is perceived as being so important that Parliament must squarely confront what it's doing. And in that case, in our submission, it makes it almost inconceivable that Parliament could have intended, in the absence of clear words, to delegate to the executive the right to curtail the franchise. In our submission, it's not for the executive to say what or isn't allowed, nor is the absence of a statute defining those rights. We don't have one. Therefore, it's up to the court finally to decide whether a right is so important as to count as a constitutional or fundamental right. It's in a society without a written constitution, this is not straightforward, but in our submission, unrestricted access to the ballot must be, according to, if it's going to happen, the constitutional traditions and the political practice which exists in this country, as one can discern it, being the test that was propounded by my Lord Sales extrajudicially in his 2019 article in the Statute Law Review. The Minister hints that we may not have defined what we mean by a constitutional or fundamental right. But in fact, we rely upon the dictum of Lord Justice Laws in Thoburn against Southern District Council. That's in the authority bundle, my Lords, at volume 6, at tab 46. And if I can, you trouble your Lordship to have a look at that.
Can I just ask, what view was taken in Muan of the right to vote in elections to the European Parliament?
I can't answer that question offhand, my Lord. The European Parliament will just check that. I can say, though, that it is true to say, in that case, we're concerned about convicted prisoners. It was dealing with the convention. I might say, my Lord, that as regards the Strasbourg Convention, the right to vote there is confined expressly to the right to vote for national legislatures. And all the case law dealing with that only deals with that. So it's not, decisions about that are not really in point here. There is a Strasbourg decision that says that there isn't a...
Well, I'm wondering what the, I mean, it's all very well to tell us that the right to vote in parliamentary elections is a constitutional right, and I don't think you'll get any argument about that. We're trying to think about local government elections, which are somewhat different, and I suspect in Muan they may have treated elections for the European Parliament as being in a different category, and in which case one wouldn't be able to say simply that any right to vote for a representative in a political institution is necessarily a constitutional right.
Well, it's... They dealt with the right to vote in the European Parliament. Was that said to be a constitutional right or not? So we're just looking up your Lordship's direct question about what they said about the European Parliament.
Yeah, Lord Hodge begins his discussion at paragraph 33 on page 206, something or other. Anyway, you can come back to it. No doubt one of your juniors can look at that.
Well, Lord, I would certainly agree that Lord Muan there is talking about the right to vote in our national parliament. Mm-hmm. I'd also agree that, and it is the case from other case law, it's been held that the Strasbourg Convention doesn't confer a human right to vote in local elections. Mm-hmm. But the reason why, so I'm relying on this, what was said here in Wuhan, as being, it is, I suppose, obiter, but it is powerful nonetheless. As regards parliamentary elections, I'm going to come on to argue that the same logical principle would apply to our system of local government. One derives no help whatever from Strasbourg, because that provision is only expressly deals with voting for the national legislature. Oddly, it doesn't apply, it's been held not to apply to referenda, even on a most basic point, such as whether a country like Scotland should be allowed to secede or not.
Yes.
It's also been held not to apply to elections for heads of state.
Yes. Well, my recollection is that the convention, I mean, I'm just remembering what Muan from several years ago, but my recollection is that the key principle in Strasbourg was whether the body in question was a legislature. And if it was a legislature, then there was a human right to participate in elections to it, but not otherwise. And if you were applying that test, then local government wouldn't be within the principle.
But as I say, that if they'd been dealing with that, it would have been obiter in the sense that it's very clear that Strasbourg only deals with national legislatures. And it's a matter simply of construction. Yeah. So this court, the guardian of the UK Constitution, can derive no real help from that, since the Strasbourg Convention does not curtail or limit the rights this court can find as being basic to our constitutional tradition and political practice, as my Lord Sales put it. So this court has to derive for itself whether the role of local government within our body politic, as it's been, and it's been around for centuries, even before the Normans, in some form or another, and since the early 19th century has been a matter of franchise, with the ratepayers voting. And since for 150 years, there's been this tradition and practice of there being voting for it's, to that extent, we say it's a constitutional right because the way in which, because within the test, it's, I can give you a reference, but it's, rather than taking the time on it, but it's a Thoburn case with Lord Justice Laws, which is at volume 6, tab 46, at EF 4007. Basically, the way that Lord Justice Laws put it was, a constitutional right is one which conditions the legal relationship between citizen and state in some general overarching manner. And
so what page number is it? Sorry.
Sorry, I wasn't going to take this. This was Authority Bundle Volume 6, and that's page 4007. And I can take a logic suit if you prefer, but it's...
Oh, okay. That's good.
If one looks there, my Lord, at page 4007, paragraph 62 of Lord Justice Law's judgment, it starts at D. In the present state of its maturity, the common law has come to recognise there exist rights which should properly be classified as constitutional or fundamental. Then he gives a number of examples. And from this, a further insight follows. We should recognise a hierarchy of acts of Parliament, as it were ordinary statutes and constitutional statutes. The two categories must be distinguished on a principal basis. In my opinion, a constitutional statute is one which conditions the legal relationship between citizen and state in some general overarching manner, or enlarges or diminishes the scope of what we would now regard as fundamental constitutional rights. It's B, which I rely upon, my lords and my lady. A and B, of necessity closely related. It's difficult to think of an instance of A that's not also an instance of B. Then he gives some examples. There's Magna Carta, the Bill of Rights, the Union, Act of Union, and most importantly, my lords, for these purposes, the Reform Act, which distributed and enlarged the franchise. Then he goes on to talk about the 1972 Act. But adopting that law, if we take a look at, if we consider the role of elected local authorities in our body politic and their importance, then my submission to exclude sections or significant numbers of people from the franchise local level is indeed to abrogate or to restrict a constitutional right. If one looks at the kind of functions that they have and they've had over the years, it's they've got functions which are in some ways more intimate and more intrusive or important to individuals such as Mr. Coughlan and those that he has represented. The many things the National Parliament does. There's decisions about secondary and primary education, transport, housing, planning, fire and public safety. There's also the right to make laws and also to have penal consequences. There's legislative powers there, and they can have penal consequences. They also have powers to raise tax, business rates and council tax. They've got powers to make the bylaws and to enforce them and to establish offences against them. So, and they also have massive budgets. In the year for 2019 to 20, government statistics show that there was about £96 billion spent by local government. So, the way that the arrangements have worked in this country have been that substantial amounts of the powers of government have been delegated to these elected bodies. Now, I don't doubt that Parliament would have the right to abolish all of the local government legislation which has existed since the 19th century for over 150 years, and instead just have appointed gauleiters in every single borough to exercise these functions. But that's not the way it's been working. It's not part of what my Lord Sales has described as being an embedded constitution or political tradition. At the moment, we have, since we do have elected representatives to decide how to tax us, how to make these laws that affect our lives most intimately, how to penalise us, we've chosen that should be done by election. And that means that that system of franchise has to be as fair and as unrestricted in its access to the voter as parliamentary elections. And this is underscored somewhat by the way in which Parliament has treated the rules that apply to local elections. By Section 36 of the 1983 Act, there it says that all the rules that apply to parliamentary elections should apply exactly the same way to local elections, unless the minister, there's a residual discretion there, thinks it appropriate to make some changes or alterations.
And sorry, the page number for that is?
Oh, sorry, that's... I'll get that for your lordship. That's at Authority Bundle 1, at E page 1440, my lord. Says that elections of councillors for local government shall be conducted in accordance with the rules made by the Secretary of State. Rules, and it goes on at section 36.2, rules made under this section shall apply the parliamentary election rules in this Act, subject to adaptations, alterations, exceptions as seem appropriate Secretary of State. Then, as the Law Commission have pointed out, it's been a matter to a large extent of chance which fundamental provisions about elections have ended up in secondary.
I mean, sorry, just on that,
Yes.
I'm looking in fact at page 1439 in the electronic bundle,
Yes.
section 36.2, says rules, well, 36.1 says local elections conducted in accordance with rules made by the Secretary of State, and 2, rules made under this section shall apply the parliamentary elections rules in Schedule 1, subject to such adaptations, alterations and exceptions as seem appropriate to the Secretary of State.
Yes.
It might be said that since so much is made to rest on the judgment of the Secretary of State, that rather undermines the profound sort of constitutional importance of the rights, at least at the fine detail that you're emphasising to us. Since the Secretary of State could, if he thought it appropriate, just change the modalities and whatever is in Schedule 1.
Lord, yes. I mean, it's. I see that argument can be made. The reality, though, for the past 150 years, is that the rules governing local authority elections have been the same as parliamentary ones, and that the fundamental rights within them remain the same. True it is, the Secretary of State has that power, but that power would be subject, in my submission, to the same principle of legality, or Henry VIII principles. If suddenly, suppose the Secretary of State suddenly decided that she was going to introduce single transferable voting as a change, I mean, just for example, that would be allowed by the general words of this section, but doubtless the courts would strike that down as being contrary to the principle of legality, in the sense it's a constitutional decision about first past the post, or decided suddenly to raise the voting age to 30 or reduce it to 14. Again, those are things which and not this section, it could be said, is really about round the edges, not fundamental stuff. And in fact, the Law Commission, in their report dated the 4th of February 2016, noted, and this is at paragraph 2.27 and 2.28, this being an additional material that was handed up, I think, yesterday. I can read it, it's quite clear, but it's quite short. They said it remains reasonably clear to us that the allocation of some rules to primary or secondary legislation is an accident of history. Those rules which have their origins in the Ballot Act of 1872 continue to be in primary legislation, even though some concern matters of an incidental character, such as the duty of a returning officer to publish a copy of any petition challenging an election result. Those rules that have a different or later origin tend to be located in secondary legislation, even if they are fundamental or important. So this is only it's a nudge, but in my submission, it means that the distribution of rights between secondary and primary legislation in this area has been a matter more of chance rather than the application of constitutional principle.
So I think possibly what you're driving at is either way we're dealing with a statutory right.
Yes.
Your point, I think, is that you say it's a statutory right of constitutional character or constitutional nature.
Lady, yes.
Yeah.
I mean, it may not, this is a minor point, it doesn't bind this court in any way, but it may be significant that the executive regarded these matters as being constitutional because these pilots were ordered by the Minister for Constitutional Affairs at the time. And another minor point is that Parliament has scrutinised these measures is by the Constitutional and Public Affairs Committee. And Lord Justice Simon's view, when he gave his leave to appeal to the Court of Appeal, gave us his reason that what was in issue was the constitutional right to vote in local elections. But of course, these are matters for this court. Those are only persuasive.
I mean, I'm not sure you get very much out of it being the Secretary of State for Constitutional Affairs. Presumably that's just the Secretary of State who happens to have had this particular area of business assigned to them.
No, not much. It's as I said, my Lord, or if I meant to say, it's just a nudge. So it's, another way of putting it is that is the ability to have an access to the ballot is something which I hope I've demonstrated that in this country, the distribution of power in government and the powers that are given to local authorities are so wide-ranging and so basic in the sense that if they can send you to prison, so to speak, for a breach of bylaws or tax you, that's the kind of thing which does attract the same importance or level of right as those powers of our national parliament. Finally, I'd say this is that if we are to have a system of universal franchise to decide our relationship with local government, that we elect people to make those laws, and we elect people also to hold their local executives to account in the local parliament chambers in the same way, by analogy, as the national parliament does, then it does become, the constitutional analysis then, as it were, if I can put it this way, kicks in, because then one does have to have a fair access to the ballot. It's, another way of putting it was the way that it was taught again by Lord Justice Laws in Ex parte Lightfoot, was approved by this court in Ray O, paragraph 43. It's just this bit. There, Lord Justice Laws is saying how important it is to restrict the rights that will count as being constitutional rights, and that's absolutely right. We don't in any way seek, by this court's decision, to expand that concept. This is an entirely conservative way of looking at constitutional rights. The way that Lord Justice Laws put it was he said the law should be astute to confine the concept of constitutional right to that special class of rights which, in truth, everyone living in a democracy under the rule of law ought to enjoy. So, my Lord, that really...
And I'm so sorry, page reference, it does help us.
I'm so sorry, yes, it's, that comes from Ray O, which I don't think it's actually in the bundle.
That came separate to us, yes.
It's paragraph 43 of the judgment there where there's a quotation. It's simply really approving what Lord Justice Laws said in Ex parte Lightfoot. So there, if these rights are to be the rights that everyone should enjoy in democracy under the rule of law, that must import two things. The rule of law, your Lordships have in a number of judgments, most recent being Unison, I think, have protected the unrestricted right of access to the courts. The other branch of government, but in a democracy, it says here, that must mean an unrestricted right to the ballot. So for the courts, thus for the ballot. And this is a critical overarching relationship which the citizen has with government. The three branches of government: legislature, whether local or national, has to be the vote. Torts, it's access to judges. Executive, you can only have a relationship with the executive or control it if you have access to one or the other. You have to be able to vote to be able to get your representatives to make the laws or to question the executive, and through the courts, access to by way of judicial review. So these are all reasons why the right to vote over bodies of this sort are, we would submit, therefore, constitutional or fundamental rights.
Can I just ask you this? Section 10 is makes provision for pilot schemes for local elections. But I think, am I right in thinking that the Howarth report actually was interested in elections more widely and participation in elections more widely?
Yes, they were. I mean, yes.
So my question is there some significance that the pilot scheme regime that's been introduced has been focused on local elections, it being perhaps thought more appropriate to experiment with local election voting rather than what might be thought to be, the higher up the hierarchy of importance, parliamentary voting?
There's, I believe that's right. It's the idea of using them, because the powers under Section 10 enable one not just to test this within an entire borough that agrees to have the testing done, but it also can be part of a borough. The pilot could be, and maybe with some statisticians may say should be, but it's no part of this case, a better thing to do would have been to have one borough where you had some wards that had one system and others another. I'm not making a submission about that. But it could be right down to simply one or two wards. So I see the inference that could be drawn, but doesn't that mean that this isn't a constitutional rights aren't engaged because they're less important? Otherwise, why just pilot there? I guess the difference is that it's true to say that if you have a pilot which is a disaster and doesn't work, you try out a new method of voting by remote, and you find that turnout plummets. If that is the case, then I think everybody would agree that that is damage done. But it's much more mitigated. It's a matter of common sense. What happens in a part of a borough, say, for local elections, is not as potentially disastrous to trust in our democracy if we tried that out in a number of constituencies at a general election, which maybe have determined the result even by who gets into government. Parliament's decided it's worth trying some better ways of voting. It's a delicate matter. Obviously, for trust in democracy, it's also a delicate matter because although one hopes they're going to work and improve turnout and make voting easier, some may not. But if it's accepted pilots are a good idea, it's a little bit like trying out a new medicine in controlled experiments. I mean, you hope thereby to increase the level of medicine generally for everyone, but you may have a trial that hurts people. But at least you restrict it, and this is a way of restricting it. It doesn't mean the right's just as important. It just means it's any more than a patient's life is more important than other ones. It's just it's a way of, let's say, testing on fewer humans, so to speak.
Well, it may be a numbers issue, as you point out, Braintree. I think the constituency tested here was about 110,000, just over.
Yes, quite, rather than affecting a result of who might get into government over 60 million.
Yeah.
Also, the other thing was that the scheme was hoping that local authorities would volunteer. And so, in fact, one needs to have, in fact, Malone Jones have pointed out, in the Howarth report, paragraph 3.1.4 at page 500, they do say, in our view, the obvious place to start is with local elections. There's some risks involved, and they go on to say that. And they say that it should be done in collaboration with local authorities. But I mean, it has to be with the agreement of the local authority. That may not be perfect. The local authority may think it's in its political interest to try, but it's better than nothing. So, my Lord, I take the full force of your Lordship's point, but it seems that would seem to be the proportionate way of trying out new voting methods, with violating as little as possible the risk to constitutional rights. So, my Lord, if I move on from that question about whether it's actually a constitutional right in our system. What is the right now? And the rights that we're referring to are Section 2 of the Representation of the People Act, 1983, and also and looking at the rules as they in fact exist now. Section 2 is at Authorities Volume 1. That's page 1277. So it's only a one-liner more, but it's Section 2.1. A person is entitled to vote as an elector at a local government election in any electoral area if on the date of the poll he is registered in the register of local government in that area. And then there's some inapplicable material about citizenship and about age. But that's a statutory right. Basically, it has been the case for a long time that the right to vote is defined as being, are you on the register? And if you are, then you have the statutory right, which we would argue is a constitutional right. So much is made by the Secretary of State of the fact that you may be required to provide documentation to be registered. However, without going into the detail about that, all of us know that generally speaking, signing a return that you or someone else is at an address is sufficient. It's very unusual to have a claim to a vote being challenged by the registrar. Indeed, differently from actual voting itself, which isn't compulsory, the registrar has a statutory duty to keep up a registration of those entitled to vote within his or her area, and has to do so by means of the annual canvass, which can include posting, can even include door-to-door visits, but there's actually a duty upon the registrar to put you on the register if you're entitled to be there. So the question is, if there is a doubt, if it appears to the registrar, as the legislation says, that you may not be entitled, then there's a power to ask for documentary evidence. Hardly ever happens. But this is the critical bit, rules, lady. If you disagree with the registrar who turns you down, you have an absolute right of appeal to the courts. You can go to a county court judge, and there's nothing about the evidence that's required for the county court judge, but you can appeal to one. And there, it must be presumed the civil standard applies. If you can show on the balance of probabilities that you're entitled, then you get to go on the register. Or possibly the burden of proof is to displace it on the registrar. It doesn't matter which, I don't know what the answer is. But anyway, it's on the balance of probabilities. So that is the right to vote. If then one takes a look at the rule...
So sorry, the provision which gives you that right is what?
Sorry, can we give you the reference? I'm sorry, you have to come a bit later. Then the question will be, what in fact are the existing rules that have been in place for 150 years about what happens when you turn up at the ballot station? And there, I think it's in the same volume, and we're at page, I think, 1938. So these are the rules which are being changed. I suppose they start at 1938. Yes, that's right, Paul.
1938.
And sorry, what is this instrument? Is this part of the Act?
This is, yes, these are rules which are made either... Actually, this is the local elections principal area rules. But it's common ground that these rules are identical for the local elections in question.
I was just asking, what is this instrument?
Sorry, this is the local election principal areas England and Wales rules 2006.
Thank you.
So Rule 30 is about admission to the polling station and about who's allowed in. It's basically voters or people helping them, or the constables. Paragraph 31, it's the presiding officer's duty to keep order at the station. If a person misconducts himself or fails to obey lawful orders by the presiding officer, he may be immediately removed by order of the presiding officer, by a constable or anybody else authorised. And he's not allowed back in without permission. And he can be taken into custody. But this is the important bit, paragraph 4, which has been around since the Ballot Act. The powers conferred by this rule must not be exercised so as to prevent a voter who is otherwise entitled to vote at a polling station from having an opportunity to vote. So you turn up disorderly, throwing your fists around, shouting, and being liable to arrest for disorderly conduct. Still, the officer has no power to stop you voting. He's got to, as you're being restrained, offer you the opportunity to vote before throwing you out or arresting you. These are strong rights. Then we see the seeing the ballot box isn't in question. Paragraph 33, we see here the only two questions which for 150 years have been permitted to the officer. Are you the person registered in the register of local government electors for this election as follows? Then he'll read it out. 2, have you voted here or elsewhere at this election for the place? And that's it. If the person says yes to the first and no to the second, then there's nothing stopping them from getting a ballot. The Crown, the Minister rather, says this is a way of checking identity or a way of providing evidence of identity. It is not. The one thing it's not is a process of verification or checking. It is merely someone can claim the right by giving those. They can get sent to prison if they tell a lie. It used to be the Perjury Act that covered this. Then, if we take a look at paragraph over the page 1940, subparagraph 3, the ballot paper mustn't be delivered unless those questions have been answered satisfactorily, but that just means saying yes and no clearly. And then this is the other important right in paragraph 4. Except as authorised by this rule, no inquiry shall be permitted as to the right of any person to vote. Now, behind those simple words lies a whole ocean of historical pain, which the 1872 Act was designed to put right. People being intimidated or questioned or possibly subject to inducements. The officer has no discretion to stop the vote. Specifically there to prevent the kind of abuses that used to exist and maybe still do in the deep south of America, where people could be questioned, or the officer could then say he had a doubt. So this, therefore, after that happens, now your Lordship and your Ladyship will notice that this is all under the rubric of questions you put to prior to voting procedure. Then we get on to paragraph 34.
Can I just check that I've understood the relationship of these to the 1983 Act? So I spent part of the weekend reading through Schedule 1 to the 1983 Act. I'm right in thinking that deals with general elections, that these rules have been made pursuant to Section 36 by the Secretary of State, and that's why they're, to a large extent, I presume, echo what is in the primary legislation.
Lord, yes. But
it's only in the primary legislation in respect of parliamentary elections.
That's right.
All right.
That's right, but the rules are the same. Then there's paragraph 34, also startling in a sense. Challenge of voter. A person must not be prevented from voting by reason only that a candidate or his election or polling agent declares he has reasonable cause to believe that that person has committed an offence of personation, or that the person is arrested on the grounds he's suspected of committing or being about to commit such an offence. These, my lords and my lady, are strong, strong rights indeed. It means it underscores the disempowerment of the officer on the desk. Once he's been told that this is the confirmation that this is the person and that he's not voted before, then almost nothing can stop the voter having his ballot, even while in the custody of the officer for suspicion of personation.
And one sees the language there, a person must not be prevented from voting by reason only that a candidate, and one sees the force of that. You can't have a candidate standing by seeing people he identifies as his political opponents and then trying to challenge them.
Yes, that's true.
What would happen if you had someone going up claiming to be the elector, and then other people in the queue say, he's not that person. I know him well. He's not that person.
Well, that means that it would still mean that, I see, because it's not covered by A or B in the sense it's somebody else,
Yeah.
a third party. And that's, well, it would appear that by the, and I haven't got the case law, but we did have below reference to a textbook on election law, which I'll have to check this. I think that there's not much case law on this, but it does cover a case where there's an accusation of that sort. But I would submit, though, that it's clear that if that person, it would be rather odd if the accusation is made and the constable on duty believes it's with reasonable cause and arrests the person, then the person can vote. But if the constable says he doesn't think there's reasonable cause and doesn't arrest, then the person can't. It wouldn't make sense. In my submission, Your Lordship's example.
So does it come to this, that you submit that even if, in effect, there's what in substance is incontrovertible evidence that the person claiming to be the elector isn't, they still have to be allowed to vote?
Yes, my Lord, and this is dealt with by the system of the tendered vote. With the tendered vote, if someone turns up and says, I'm John Smith, and the officer says, but John Smith, if that address has already voted, the person's already done that, which is exactly the message we're talking about, then the system of tendered votes then comes into play. That's at paragraph 38, deals with that. It's there, the officer still has to give that person a ballot, but it's in a different colour. He makes a note of it. This is a ballot to someone who may be a personator. And then you get a system of tendered ballots so that then, if that challenge is made good, that vote can later be disallowed. So that's in Rules 38 and 39 deal with that. So the system seems clear. You can't be stopped from voting even if you're being arrested for personation. That must include, you must be allowed to vote if an accusation is made but doesn't actually result in an arrest. Otherwise, it leads to absurdity. The tendered ballot paper deals with the mischief of someone turning up and voting when somebody else the same name has. One interesting point about this case is no evidence has emerged from the Cabinet Office or the Electoral Commission or the Minister, anyone, as to what the statistics are about tendered ballot papers historically. We do know from the Pickles report that there is virtually no evidence of personation being a problem. There's only been one conviction for personation at the ballot box. We're talking now about personation at polling booths, not postal votes. One conviction out of 74 million votes cast, and only 11 officers even suspected it out of 1,189 officers interviewed by Pickles. But there's no evidence at all about tendered papers. Going back, though, to this, therefore, my submission has been the landscape for 150 years, which is embedded in our Constitution in the way that my Lord Sale suggested in his article. So has this been changed? Sorry. The registration appeals, the right, my Lord, to appeal to the County Court.
Oh, yes.
Is at section 56 of the 1983 Act. That's the reference is volume 1 of the authorities, tab 1, and it's page 1482.
Thank you.
So those were the rules as they were then. If one then takes a look at to see how they've been changed by the rules authorised by the Minister and the pilots, we see that in Appendix Part 2, at page 826. These being the rules made for the Pendle Borough Council. There were, of course, 9, I think, but... Oh, I should say one thing I omitted to refer to more was that in the rules about how elections happen now, the title voting procedure, which gives one maybe a slight clue as to what Parliament thought of as being the voting procedure, doesn't apply to the rules about asking the two questions. Voting procedure, as as set out in the rules about what happens at the polling station. It's the questions are asked beforehand, which is about the polling station. Then you get the title of voting procedure. Then you get the bit, which is about the issuing of the ballots. So it's a small point, but it indicates that if the Court of Appeal were right about what the voting procedure can be something wide, according to these rules, it only starts at the time you get the ballot, and then the rules about how you put the cross on it. We're going back, though, to the Pendle Borough Council. Identification in polling, this is a pilot order. And the rules in question, which are under challenge, are the ones which are at page 830. And where it says Rule 35 has the words, at the beginning of paragraph 1, insert, subject to paragraphs 2A to 2I. Those go after the words which then are putting the duty on the officer to issue with a ballot. So it's a subject to this happening.
And I'm so sorry. Is this one of the orders that is under challenge?
Lord, yes.
It is.
It's the one for Pendle Borough Council.
Right. Because I think the statement of facts and issues focused on the Braintree one, but this one's under challenge as well.
Yes, it is. All of them are subject to the challenge.
Okay.
So here it says there's a duty. A ballot paper must not be delivered to a voter unless that voter's produced a specified document.
Sorry, where are you?
I'm so sorry. That's 830.
830.
It's that's in the Appendix Part 2.
Thank you.
A paper must not be delivered to a voter unless that voter has produced a specified document to the presiding officer or clerk. Where a voter produces a specified document, then the presiding officer or clerk must deliver a ballot paper to the voter in accordance with paragraph 1. And this is important, unless the officer or clerk decides the document raises a reasonable doubt as to whether the voter is the elector or proxy he represents himself to be. And then there's a duty where the presiding officer, where it's him that decides, he must refuse to deliver a ballot paper to the voter. And if it's the clerk then shows it to the presiding officer who makes the decision. The decision of the presiding officer may not be questioned in any proceedings whatsoever, other than by way of election petition. Where the presiding officer refuses to deliver a ballot, he must record why. And then there's a list of the documents that will count. Now, in Pendle, the documents at 2G were all photo identification documents. Passports, driving licenses, and the other documents there listed in 2G. There is, if you haven't got any of those documents, then there's a way of being able to get a document from the registration officer, which is over the page 832. Electoral identity document. It says that this rule applies where a person makes an application to the returning officer for electoral identity document, and that can be made by someone on the register. But then you've got to give your details, and you've got to then also say at 3.3, you must confirm that you wouldn't be able to provide the required document. So you've got to confirm that you haven't got a passport, haven't got a driving license, etc. And then you've got to produce other documents there, which may be, broadly speaking, evidence you have bank accounts or mortgages or tenancies, or that you are a householder of sufficient status to be responsible for utility bills, or that you do have access to birth certificates or marriage certificates, or the like, or that you've been in employment. So what we'll be coming to here when I talk about the restrictions are this will automatically exclude many transsexual voters, transgender voters. And that comes from the intervener's case. The reason is this: a number of people who have been transgender would have changed their appearance from one gender to the other, would have maybe, and also then the result of that then is, if they have a passport, and it takes time to update passports, if they have a passport where they're called John Smith, but in fact they've transitioned and now they're Joanna Smith, that means that they can't sign a declaration to say, I don't have any of these documents, because they will have a passport. But if they turn up at the polling booth with a passport where they look like a cis male man, but in fact now they have the appearance of a woman, then the officer on the door will be obliged by law to exclude them, because he will then have a reasonable doubt. Also, the name won't fit anymore, because the male name won't anymore fit with the female appearance. So that's a very specific problem. And another one is, it does interfere with the constitutional right in this sense. You're entitled to vote if you're on the register. And you can prove that right on the balance of probabilities in front of a judge if your local officer has a doubt about you. So you have a right to be on the register on the balance of probabilities. This rule alters that constitutional right by saying you now have to prove your entitlement beyond all reasonable doubt. And that does interfere with the statutory rights as well. Of course, there's plenty of evidence before your lordships that many people won't be able to find these documents. People of the sort that my client is describing, people that have chaotic lives, or people that it's not difficult to imagine. Younger people, for example, in multiple occupancy, aren't responsible for utilities, don't have bank accounts, don't have mortgages or tenancy agreements, working in the gig economy, possibly by an exploitative employer that doesn't obey the rules about PAYE, doesn't obey the rules about having to give out P60s or 45s. And that people in that section, just for example, will certainly find it hard, if not practically impossible, to vote. And many, many people in less straitened circumstances will find that their rights, their ability to, is hindered or restricted. So well, that's the way the pilots change it. Now we have an officer on the desk who now, we're going back to the 1860s or earlier, or we may be bringing in the abuses which once existed in places like Mississippi. This is not the intention of the minister, and there's no doubt placed upon the motives. But this could well be the impact. And bringing in such a major change is something which affects the constitutional right, something which, I'm going to come now to the provisions of the Act and the explanatory notes, and for your lordships and my lady to ask themselves whether or not this is foreshadowed in any way by the wording of the statute or the explanatory notes. Next to that, if I may look at the background materials first, and background materials of this sort in the recent judgment in Ray O, the paragraph 30, suggests that they are admissible for interpretation in the case of ambiguity. I would simply as well in the case of the application of the principle of legality. First, if we look at the explanatory notes, there we see those in volume 1.
I should tell you, we don't have the volumes, so we just need the electronic page reference.
That would be at E1803. There's some bits of the explanatory notes to this Act which I'd like to draw the Court's attention to. If one looks at page 1803, there's paragraph 3. The Act changes electoral procedures in relation to registration, and absent voting allows for experiments involving innovative electoral practices. And then paragraph 6 references the Howarth report, and specifically says this Act is to give effect to the Working Party's recommendations. So this is, in my submission, is an important aid to interpretation, because it says the Howarth report is specifically what was supposed to be.
I mean, frankly, notes like this are of very little assistance. The key terms in paragraph 1 have been prepared by the Home Office. They do not form part of the Act. They have not been endorsed by Parliament.
I'll be correct if I'm wrong, Lord, but as I understand it, explanatory notes are one of the aids of construction which are admissible in this court.
I think what was said in the case you just referred us to is that explanatory notes prepared under the authority of Parliament may cast light. I don't want to waste time arguing with you about this stuff, but I have to say I find it of very little assistance.
Well, there's in paragraph 30 of Ray O.
Yes, that's what I just read out to you. Let's not waste time on this. If you want to take us to it, let's get it over with.
Well, I hope it's not quite as bad as that, my lord. It's, I mean, these are secondary interpretation, not. But it seems common ground with the minister that these notes are up for grabs, my lord. I'll only refer your lordship then just to one point, which is at paragraph 10, though, summarises what the Act actually does, which is there's provisions that make it easier for the homeless or remand prisoners or mental institution patients and service personnel to register. This is not controversial in the sense that there are sections that say that. So this is just simply shorthanding what the legislation says. And in subsection 27, it says that this Act does not alter the franchise. So if in fact powers under the Act are now being said to have that effect, this is a slight push. This is a secondary source of interpretation, my lord. It gives that push in that direction. I'll leave that, though, my lord. But then if I can take your lordships to the Howarth report, though, which was...
I mean, I'm so sorry. I mean, the pilot schemes don't alter the franchise, do they? I mean, they alter the methods by which someone verifies that they are someone with the vote, but the underlying right to have the vote is the same, isn't it?
The underlying substantive rights remains unchanged, my lord. But the impact, though, if the impact is effectively to remove the franchise from certain people, then it means the effect is out with that. It means that the franchise has changed. The example I gave of the trans voter is someone who would have the franchise removed. They have a passport, no longer a cause with their appearance, they can't change it, or the name, and then they must be excluded because they can't then get a substitute document. It may be an entirely unintended consequence, but nonetheless it's a consequence. And if subordinate legislation has that effect, then it has de facto removed the franchise. My lord, the other point, though, is that, of course, a procedural obstacle can amount to being something as bad as a substantive change. And in the common law, we know that in many ways over the hundreds of years, that often the way of preventing a right from being exercised is by a procedural rule, whether it's a statute of fraud saying only in writing, or no action can be brought, or estoppel. We all know that these procedural rules can block a right. The Court of Appeal held that the imposition of these identification requirements didn't have the effect of restricting a right to vote because of the point that your lordships just made about the register. But actually, if in fact a right is blocked in the way it would be for trans people, then it is blocked. And one doesn't then look at whether a right is in some theoretical or theological world still exists. It's a question of practical reality. Furthermore, we submit also the test as to whether a constitutional right has been interfered with isn't one of impossibility, although that is the case with these trans voters that I've been talking about. But it's sufficient if the constitutional right, if there's a risk it's being restricted or hindered, which was the test which was adopted by this court in the Unison case, leading judgment of my Lord Reid, that when there was evidence that there was going to be a risk of hindering or restricting, that's enough to engage the principle of legality, and that is clearly the case here. The Howarth report, though, is something which common ground. The Act was designed to give effect to that, and it's a document which does aid construction. If one looks at that at E461, just the references in question, if one looks at E465 at paragraph 1.1, and this is a cross-party committee which is expressing a consensus. There's the concerns that interest in democratic process, as measured in part by participation in elections, is showing a decline. If one turns over to page 466, then at paragraph 1.5, halfway down, they say we've seen no evidence from the work we've undertaken that we should be concerned about legitimacy or fairness of elections, which is the view that the Home Affairs Committee also reached in their inquiry. Their report is also annexed here. And if one takes a look at, we'll be taking a look in a moment to the Home Affairs Committee summary recommendations, because that's annexed to this report. If you also look at page 468, about 6 lines down from the top, one sees that Home Affairs Committee is referenced there. If one then moves on to page 499, these recommendations then found their way into section 10.1. The heading there is improving voting arrangements and making voting easier. And as a secondary source, I rely upon that, my Lord. It's if there's any ambiguity in the actual section itself.
Is it quite clear that, obviously the legislation was almost 20 years later than this report?
No, this report predated the legislation, my Lord. This Howarth report.
Oh, I'm sorry.
Oh no, this report.
Right.
It was the purpose of the legislation was to put into effect this report.
Oh, I see. Yeah.
That's why we see halfway down the page on page 499.
Thank you.
Pilot schemes of alternate voting arrangements.
Yes.
We look at paragraph 3.1.2 on page 499. They say that the old procedures are over 100 years old. Doesn't mean they're necessarily inadequate or ineffective. And they've been tested and largely retained electorates' trust and support. But the evidence of falling turnout at all elections and apparent disenchantment with the traditional forms of democratic participation in ballot box suggested that there's now time to consider a review. And then we have a pilot scheme of alternative arrangements, which is what?
Well, just before you leave that paragraph, I mean, the final phrase of it is to consider a fundamental modernisation of the electoral process. So does that not rather suggest a holistic overview? I know the point is raised about encouraging voting and facilitating voting. Those phrases
yes.
Jump out, I can see that. But is it not, was part of this not to look at the electoral administration process in the round on an overview with modernisation in mind? And also, was it not going to be an organic process through pilot schemes? In other words, I mean, remote voting was a highlight that was taken up, obviously. But is it not too narrow simply to look at this without that focus, that this was holistic and looked at an overview and modernisation of electoral administration?
My lady, if the comment had ended there with fundamental modernisation with those words, then that would lead with that implication. However, the way in which they then go on to recommend that we're going to look at pilots are severely restricted over the page we'll see, just to these 3 ways of testing new things. It's so first of all, the report only links it to the where, when and how, as we're about to come to, which is mirrored in the legislation. But there's an important point, though, which is, one might say is a constitutional point as well, is that Parliament has chosen to restrict the pilots just because pilots are dangerous, because pilots might interfere with the constitutional right to vote in ways which are unacceptable. So they've tied it here, Howarth has, as Parliament did, they tied it only to when, where and how, and not vague words like modernisation, which in truth means nothing. Because it just means doing things differently from how they were done 100 years ago. Or it might mean it when new technology might come in. But it's been tied. So if one turns over the page... Well,
are you suggesting we disregard that final part of 3.12?
I think...
Now time to consider a fundamental modernisation of the electoral process?
It's because then when they talk about pilot schemes, one doesn't disregard it. One then says, it's like saying, well, it's now time to consider fundamental modernisation. That is to say, pilot schemes, now we're saying here, these massive changes about you may be able to vote remotely or on lots of different days or at night or whatever, and also you can vote by telephone or you can vote. It's as if it then says that is to say.
Yeah. But in any event, it's progressive. The tone of the report is progressive.
The tone of the report's progressive. Oh, yes. But only progressive, the relationship I would respectfully agree, if the object and the purpose and the effect in the end of the vires is to make voting easier, get more people to vote, not less. Okay. Because, I mean, in the end, one thing which is a sharp-edged aspect of this case is one could imagine pilots where they're designed to try and improve voting, they don't work. Such pilots are perfectly intra-vires because you've tried a new method of voting, like by computer. It hasn't worked, it's a risk you take. The thing about this pilot, these pilots, is there's no modernisation at all in terms of when, where, or how you vote. None. It's exactly the same system as before. There's no change, except you suddenly have this barrier to doing what you've always done before, which some people, like trans people, cannot meet. That's not progressive. That's regressive. And we say it violates a right. Now here, this is not what they're thinking of. Here, piloting alternative voting schemes. And one point, just being on my junior, is that a requirement to produce papers is hardly modernisation. I mean, under Napoleon, French people had to produce papers. That is not modernisation. So in paragraph 3.1.4 over the page 500, in our view, I've taken ownership to that before, we start with local elections. But then, in paragraph 3.1.6, in developing the list of innovative reforms of voting practice which we believe might reasonably be introduced through pilot schemes, then it breaks down to three categories. So the answer to your ladyship's question was, it is that is to say, there's these three categories. When to vote, changing polling hours, or moving polling days to a different day, or opening some polling stations very early, and then they talk about implications about faith and about other traditions in the community. But one thing is quite clear in the context. This is envisaging having more time to vote, not less. This is not envisaging trying out a pilot where you only have 2 hours to vote rather than a full day. Where to vote? This could have, it says in paragraph 3.1.9. Pilot schemes could address a number of issues about location, out-of-area voting or mobile polling, or taking the ballot box.
Sorry, just before we move on from 3.1.8,
yes, sorry.
if you look at the last sentence, early voting would also require close control of the registers to prevent double voting, using different polling stations and so on. I mean, isn't it clear from this report that whilst the general theme is to make voting easier, something that runs with that is the question of verification to make sure that the right people with the rights are, and only them, are the ones that vote?
Absolutely, my Lord. Absolutely right. But that, as I urge upon your lordships, only comes into play once you are making a change, designed to be a change for the better, in when, where, or how you vote. Here, if they're saying you could have multiple polling booths, that's a change for the better under the when. Sorry, the where. But that then might bring with it a need for greater security to prevent double counting. But that is then in the name of trying to render secure a change in the when. The thing about these pilots is there's no change in when or where or method of voting at all. Nothing new is being experimented. There's, and if in fact it's a fair purpose of this legislation, and we'll come to section 10 in a minute, that the point is to increase turnout and the point is to make voting easier, there's not a single voter in the country. There's no additional voter in the country to be had by this scheme. There's no one who can vote now that will be enabled by some new facility to vote or make it easier than they did before. No one. These schemes can only at best be neutral. They can't add a single voter. What they can do, and what they inevitably, in a practical world, in the way that my Lord Reed put it in unison about what the practical reality is in the real world, as my Lord Reed put it, in the real world, these will have a depressing effect on turnout. There'll be many, many people that can't or find it's too difficult. No one There's no way it can go up. And that really is, if I'm right about purpose behind all this, is the real reason why this is ultra vires. So, where to vote, page 501. And then if we take, again, similarly, it's a question of having more. Now, how to vote is over the page on 502. The pilot schemes might propose moving completely away from paper and having a remote system. So it could be all postal ballots, all automated voting, or vote counting, replacing manual voting with electronic machines, telephone voting, electronic voting online. And then they go on to say, as my Lord Law says, I respectfully agree, if it's going to be remote, you've got to have some way of securing it. Of course you do. And then they say it's convenient to offer examples of the kinds of pilots. There's nothing here at all to alert the reasonably conscientious MP reading the background papers and wondering how to vote on this legislation, that a measure of this sort in Braintree or Pendle was going to be brought in. Nothing. This is all about new ways of actually casting or making your vote happen.
But I mean, electronic voting might exclude some people. I mean, it's quite a familiar problem with public policy, where as government shifts online, that a lot of people don't have access to computers and so on, and that raises various problems. Isn't part of the point of the pilot to see how big these problems are, what methods can be used to work around them, rather than to ensure absolutely no one will be affected detrimentally while the pilot is in operation?
Well, yes, absolutely. I mean,
well, sorry, that's a point against you, because you seem to be saying that if one can imagine, a person or maybe a small group of people who may be prevented from voting under the pilot, that makes it all unlawful.
No, that's not my submission, my Lord.
All right.
No.
I thought that was the purpose of the focus on the trans people.
No, it's under this particular pilot, we happen to have some people that will be inevitably prevented. That's what puts it out. Also,
right.
but also...
Well, all right. Now, let me just press you then, because if you've got electronic voting, it might be said some people will inevitably be prevented.
Yes. Well, that, first of all, would depend precisely on the terms of the pilot. Yeah. And it may be that there isn't a group that obviously are prevented, depending on the facilities that are put in place for being able to vote remotely. Because it may depend, can you do it from home? If you haven't got a computer, can you go to mini stations where there is one available to the public? There may be ways of doing that which don't have that effect. But on the vires point, then, more it's this. I can't stress this too much. If the minister is changing the method of voting, like by electronic voting remotely, then he's in through the door of having changed the method, the how. And if it's if that's a different method of voting, it then brings with it a different way of being able to communicate your identity as well as communicate your vote. The communication of identity has to be different because you're not talking to an officer directly. That's an inevitable part of it. But you're through the door as a minister because you are trying out a new method of communicating a vote. Then that's going to be intra vires, the power, unless there's some extraneous reason that shows it's for some reason unreasonable exercise of the discretion. Then you're in, so to speak. Now, the reason why it's reasonable to pilot that is because this report notes, and we all know, that there are some people that find it hard to get themselves to a ballot station. There's some people that find the present way of voting now inconvenient. And so the question is whether we can think of a new system of voting which is going to make it better. Now, some people now might practically find it very hard to actually vote, just going to the ballot station. The purpose of this is to try and make it easier. So the reason why there's that kind of utilitarian balance is that if you try out a new system and pilot it, like by remote voting, you compare the turnout and the success of that to what it was just on a paper system. And that's why it's a legitimate thing to try out. And of course, that may involve a different...
Yeah, I mean, but isn't the practical reality, you may end up just with a different distribution of people, who find it easier using computers and so you'll boost voting from them, but other people don't, and we're perfectly happy with with turning up in person, and maybe you're going to lose some of them. The whole point of the pilot, one might think, is that there should be experiments to see what the overall impacts might be on different, distribution of voters within the system.
Yes, that is precisely the point of them. It's because you find out then how the pilot works. No system is perfect.
Yeah.
And then it's up then to the minister to decide whether or not, taking all that into account, it's a better system. And
I mean, that being so, one thing that was in my mind in relation to the interveners cases, which you've relied upon, is it did seem to me that one might think that those would be the sort of points that would be made in the light of pilots on the basis of actual experience of people saying, well, I was in this area, I wasn't able to turn up, and then there could be adjustment to the system in the light of that experiment and in the light of that experience, as opposed to relying on it, as you seek to do, to show that the whole experiment is unlawful.
well, I see that. It's just that in this, I suppose the anterior point is the point that this isn't experimenting with a new means of voting, and so that puts it out ultra vires anyway. And what makes it even worse, since, as I've said to your lordships, not a single extra vote is going to be garnered by these pilots, is it actually, to make it yet worse, is it actually does bar some people completely with no good. But I take your lordship's point that if in fact one has a bona fide and reasonable pilot, which does try a new method, then of course there will be that kind of balancing act at that stage. There will be then all those matters to be taken into account. But such pilots were envisaged by Parliament. Such pilots, if one looks, I'll take the lordships to section 10 now. It is that Parliament had in mind. Pilots designed to increase or make easier voting overall. And yes, there might be some people that find it harder as a result, but if overall it's going to improve turnout, it's within what Parliament contemplated. This, my submission, is not. This sudden introduction by the back door, so to speak, and by Section 11, it could be made permanent throughout the kingdom, of the requirement for identification. This is an issue which is a hot political potato. This is not for this court or for us to determine whether it's right or not. But one can take judicial notice of the fact that introductions of ID cards have been highly controversial. They were after the war. They were tolerated during the war. And the debates in this same government, a little after, under the Blair government, the unusual defeat of a government with a large majority as ID cards were voted out. This is a hot political potato. If it's the kind of thing which, if you were going to authorise, is a very kind of thing which either the Henry VIII provisions or the principle of legality should have had in red letters, so that Parliament knew what it was being asked to authorise. And then clearly could see it. My submission, the test is whether it's there in our written argument, but in practical terms, in the real world, would a reasonably conscientious MP reading all this material and reading the Act I'm about to take you to, would they have in a million years have thought this is going to mean there's going to be no testing of new where, whens or methods of voting, we're just going to bring in an ID requirement? That would have led to an explosion, no doubt. There would have been a controversy in there, but that hasn't been foreshadowed. So if I can take you to, I think, section 10. I can't do it all. And that law is at
Is one of the purposes of the Howarth report to increase the legitimacy, the authority of the elected representatives by increasing the number of people who vote? That is, that one of the purposes is increasing legitimacy. Would that be correct?
Yes, I think that's what they say.
And would increasing legitimacy also be achieved by having voter identification so people could have confidence in the legitimacy of their elected representatives? For instance, allegations that votes or elections are stolen would be diminished?
Lord, yes. I mean, there's no question that no one likes electoral fraud, and no one wants it promoted. We want it diminished. Of course, everyone does. The question, though, my Lord, is how is that going to be rationally tested by a pilot? it's the thing about pilots.
I was more on the purpose of the Howarth report as to looking at the fundamental underlying purpose.
Well,
modernisation, legitimacy, increasing voter participation.
Well, except, let me put it this way, my Lord, it's through the methods they say this can be done by is they're saying there can be pilot schemes to try out new ways of voting in the when, where, or how. It's, as I was submitting to my lady, there are these general words about trying to have having greater participation in the system, maybe greater faith in it. But these are then all tied to these three types of pilot. That cuts it way down. Also, there's the simple fact that that in paragraph 1.5 of their report, which is at page 466, I think I read it to your lordships, we have seen no evidence from the work we've undertaken that we should be seriously concerned about legitimacy or fairness of elections. So actually, they weren't concerned about fraud. There's also...
Well, that might have been the situation then. I mean, things can change. They clearly were concerned about fraud because we see them talking about, you know, the verification procedures if you change the method of voting.
When you change a method of voting when you haven't got the face-to-face thing, of course you've got to change it then. Yeah. Otherwise, there's no way of being able to ask the two questions. You've got to do something else to identify the voter. So, yes, of course.
I mean ultimately, the mischief rule is simply one aid to interpretation. As Lord Sales says, although they weren't concerned in 1999 about electoral fraud, we've had since then, I can think of at least one example of an election having to be rerun because of fraud. The issue, I mean, someone can well understand why the Home Secretary might want to run a pilot that would discourage fraud. And the issue really is whether the language of the legislation, construed properly, accommodates that.
Well, Lord, I suppose the answer to that is that if Parliament was very clear about tying pilots, which do after all interfere with ordinary election rights in real elections, because these local authorities will sit then for 4 years, whatever it is, the power has to, when Parliament gives the power to try these things out, it must be tied to their words. And
yes, of course.
And that means that the concerns they had at the time are the ones they had at the time. If you are then going to have a different concern about electoral fraud, then you need to have a separate power then.
No, it doesn't follow at all.
But it's
the issue is simply whether addressing that is covered by the scope of the statutory language properly construed.
Lord, yes. But then if there is, I mean, I've endeavoured to say that the language is clear. If it's not, then looking at the mischief that was then identified is a clue to construction.
Yes, it's an aid to construction. But at the end of the day, the law is the text of the statute.
Well, if we come to that, my Lord, I've got to say that I may not have time to deal with an important background document, which, although I can take from your Lordship doesn't give much weight necessarily, which is the Home Office Home Affairs Committee. If I can just give references there, it's referred to.
I mean, we have read 50 pages of mostly background material in your written case.
Yes, well, it's paragraphs 55 to 57 in the event. The point is, my Lord, is that so far as the Home Office response was concerned, they specifically disavowed the 2 points to be made from it. One is they focused on the physical process of casting a vote. That was what they said this was going to be about. Now, I appreciate that's not the words of the statute, but it's a background. And the second thing was they disavowed any need to have identification at the ballot box. They said that wasn't part of what they had in mind, which is what one sees.
Page reference?
Sorry, those are... Sorry, yes, it's a fourth Home Affairs. It's the page reference there is... so I think it's E445.
And your references to paragraphs 55 to 57, I think, were to your case.
Lord, yes, I'm grateful, yes. And then there's the Home Office response, which is E454, I think. The important thing is that in the Home Affairs Committee extract, we've omitted there paragraph 102. But we know what's in paragraph 102 because it's referred to in the Home Office response, where there they say, they refer to the fact that the Home Affairs Committee said there was no need for bringing in identification requirements. And the Home Office agrees with that. Let me just check I've got that right.
I may seem to be making a fuss about this, but you've cited the judgment that we handed down 2 weeks ago, and the whole gist of that is to focus more on the text of legislation, reading legislation in the context of the other provisions of the Act, and to waste the court's time a great deal less in looking at background material.
Except there seems to be a judgment there, I think it's paragraph 30, which suggests that there's explanatory background materials are admissible and helpful as a secondary source of interpretation, as a secondary source. So it does seem to give an encouragement to look at it if there's a doubt about interpretation. The case also seems to point out the primacy of constitutional rights, although in that case they were not engaged, because it was a citizenship right. Maybe if I can take the Lordships now, I've made the point that the background papers disavow any interest in ID, but Section 10...
Certainly, and I'm so sorry to... I just want to check something. I had the impression that really the Howarth report had superseded, had replaced these previous reports.
Well, they annex the previous report.
Right.
Without disavowing them. And they say in the body of the text that we were doing this work simultaneously, and we pretty much agree with each other, if I'm paraphrasing there. But because they annex Appendix E, the Home Office report, that indicates that they, without more, tends to indicate a broad approval of it.
Yes, I see. Thank you.
So paragraph 102 referred to, so it disavows an interest in fraud prevention. And they pretty much, they say the same things anyway, pretty much. If I can take your Lordship to the Lordship's Section 10, which is, of course, what this is all about. That's at 1690. 10.1, where a relevant local authorities submit proposals for a scheme, then missing out words, the Secretary of State's got the power to order that scheme when the words in brackets, which may include provision modifying or disapplying any enactment. So this is very wide. We say this is a Henry VIII provision. Then going on to subparagraph 2, a scheme under this section is a scheme which makes, in relation to government elections in the area of a local authority, provision differing in any respect from that made under or by virtue of the Representation of People's Acts, as regards one or more of the following, namely, now stopping there, my lords, this is a power to change any primary legislation at all.
But in fact, what it has to change is subordinate legislation, doesn't it? I thought that was the point of my questions earlier about us looking at the rules which apply to the local authority, local elections.
The ones we're looking at, my lord, is as it happens, they are in secondary legislation.
Right.
But because this power can be used as a Henry VIII power for primary legislation, our submission is that the same rules about Henry VIII construction apply, especially as the Law Commission has pointed out. It's a matter of accident whether these important rights are in secondary or primary legislation.
But the only rules that you've shown us which are relevant are all in subordinate legislation, aren't they?
Yes.
Okay.
One second. But this power, if one were to take the wide construction put on it by the Court of Appeal, would include a power to change primary legislation, such as secrecy, which exists, secrecy about is in primary legislation. And it would involve a change to that, or it could involve a change in the criteria for registration to vote. So because on the wide construction put on it by the Minister and by the Court of Appeal, we say that the same Henry VIII, that the court should say that this should be construed like Henry VIII power, even though, in this case, it happens to be dealing with secondary legislation. So now, this is where we find that this power to change the law is cut down. Only one or more of the following, it says, namely, the when, where, and how elections is to take place. And I repeat there, that, if one looks at it there, it's at the elections. How voting at the elections is to take place, the emphasis on voting, how the act of communicating a choice of candidate is to be achieved. And I submit that's what those words mean. And there's no strange construction upon those words. And it's quite inappropriate to be having a wide construction put on them, artificially wide, we would submit, in order to enable any pilot about anything to be allowed. That's contrary anyway to constitutional theory. It's also it's a bad way of looking at it when we're dealing with a fundamental right like the right to vote. Then we've got about how votes are counted and about communications. And so they don't apply here. But then they give some examples over the page on 1691. It's for voting to take place on more than one day. These are just examples. And at places other than polling stations. This all shows the idea is to expand the ballot, de facto and de jure, and not to actually do the opposite. And then there's the power in 4 to have these schemes throw out an error in parts of it. And then in subparagraph 6, a report has to be given. The Electoral Commission didn't exist when this legislation was first passed. Very important to bear that in mind, my lords, when we construe this, because this has been regarded by the Court of Appeal as a major safeguard that Lord Justice Underhill persuaded him to prefer a wide construction. But that, in our submission, was an error, because we have to construe these words as Parliament saw them first. The mere insertion of an Electoral Commission later wouldn't have changed their basic broad meaning and effect.
And can you help? Where do we have the text of the Act as originally passed?
I fear they may not be in the bundles, my lord. One can see the things that are added and the things which are in square brackets. If we can provide that, my lord.
Yes, thank you.
And then the report in particular shall contain. Again, the words in particular were added after the Electoral Commission was passed. This does not, however, expand the vires of the where, when and how. It doesn't mean you can suddenly have a pilot just to look at cost, say, however desirable it might be. Now, these are the bits that we say are so significant in looking at purpose. An assessment, this is 7C, an assessment of the scheme's success, the report shall in particular contain, we go down to C, shall, so this is mandatory, an assessment of the scheme's success or otherwise in facilitating voting at the elections in question. So we say the point of this is therefore to facilitate, to make more possible voting. Now,
sorry, this is the report by the Electoral Commission, so this isn't the original.
That's right, I think it was originally going to be by either the Minister or the local authority, I forget which. But this was always going to be in the report, whoever was going to be doing it.
Okay.
They must have that. Now, the Minister says, but it says or otherwise. So it could be unsuccessful. But no, the point of this is not to have an unsuccessful, the point is to have one that facilitates. Then you report as to whether it's worked. Then second, you can forget 2 because it's about counting. Then at the bottom, it's a success in encouraging voting at the elections. That means making it easier, not worse. But then, in paragraph 8, we have some mandatory statements that have to be in the report. It must have, in their opinion, whether the turnout of voters was higher than it would have been if the scheme were not applied. Now, that is a direct, we say, indicator that the purpose of the scheme must objectively have the possible effect of increasing turnout. You're comparing the laws we have it now to the new laws that are being put into place. Are the new laws going to increase turnout? In this case, my lords, we know they're going to decrease it and can't increase it. And then, in B, did the voters find the procedures provided for their assistance by the scheme easy to use? This is envisaging new ways or places or times to vote, which will make it easier. And it's for their assistance. How can the minister say that making people produce papers, some of them difficult, is a procedure provided for anybody's assistance, or make it easier for anyone?
Well, they might say that eliminating or making more difficult the commission of electoral fraud when people come to vote would promote trust in the electoral process, and which was clearly one of the aims emphasised by the Howarth Committee. And the promotion of that trust would encourage more people to vote.
Except the House Committee, well, encourage, yes, but this particular bit, my lord, is, that is the point that they make. I'll come to that in just a second, or maybe in reply. But here, these words are saying, it's a mandatory statement. In your opinion, did the voters find the procedures provided for their assistance by the scheme easy to use? Point is, there is no procedure here which is provided with the assistance of anyone.
But if I may say so, I think my Lord's question is really directed to A, it's the turnout. So it would conceivably be possible that if there is concern that people are voting who shouldn't be allowed to vote, so your own vote doesn't count for much, maybe you wouldn't turn out at all. But if you can be reassured about that, then you will, and then the turn-up will go up.
I mean, clearly, encouraging voting is something which this legislation is concerned with. One sees that in subsection 7C, the last two lines. And if you do encourage voting, then one would expect the turnout of voters to be higher than it would otherwise have been.
My Lord, as regards that is a point which is an argument which is brought against us. First of all, the words encouraging voting elections in question, enabling them to make informed decisions, that is really aimed at bringing in changes in electoral communications, rather more. But if it is a general encouragement, my Lord, first of all, I would adopt the view that was given, at least over to by Lord Justice Underhill at paragraph 79 of his judgment, that he said, I have to say I do not find it very plausible that any significant numbers are deterred from voting by the perception that other people may be voting when they're not entitled to.
Well, he's entitled to his opinion, but what status does that have?
Well, my Lord, the status here
If I were a voter in Tower Hamlets and I'd experienced what was going on there in 2014, and I saw that steps were being taken to reduce voter fraud, that might well encourage me to vote, where I previously would have given the whole business up as a bad job.
Well, first of all, the Tower Hamlets matter was that was a scandal surrounding postal voting. There's been fraud in postal voting, which is what
it wasn't just postal. It wasn't just fraud in postal voting.
I think there were just two convictions to do with personation at the ballot box. But the report that was done by His Honour Judge, sorry, I forget his name, Amori, was dealing with the postal voting scandal. Secondly, there's only been one conviction for impersonation out of the last 74 million votes cast in this country.
Oh,
and thirdly, my Lord,
this isn't an answer to the point. The only issue is whether, looking at the language of the legislation, encouraging voting at elections seems to be one of the aims which a pilot scheme could legitimately have. And the fact that that particular issue is required to be covered in the report might be thought to suggest that it is.
Lord, there's 4 points against this. First of all, it has to be whether the voting has been encouraged at that particular election, because it's at the elections. Second thing is that this entire argument that encouraging voting could be a purpose by bringing in ID was a late change in purpose by the Secretary of State. It's always been about preventing fraud, and it was a purpose that was late, that was only mentioned after it was drawn to the Secretary of State's attention in the press that encouraging voting was what was needed to bring this intra vires. The second thing is that this is not the kind of thing, if one's got the view that maybe, the way that the Minister puts it, is that you might be encouraging voting in the future by piloting ID requirements now, which is the idea that if we start doing this, it might mean it's a long-term effect.
Well, but that's a straw man. It's encouraging voting at the elections in question.
That's right. So that part of the argument can't work, but that's what they're saying. They're saying that they can use these pilots as a kind of advertisement, which that's for future elections. But as a matter of construction, my Lord, it cannot, my submission, pilots have to be designed to try and, we have to look at it all in the round. They have to provide procedures which are for the assistance of the voters and making them easy to use. that encouraging has to be read along with those words. They have to be encouraged by the fact that they've got procedures provided for them which are going to be easier.
Well, but there is an opposition in 7C between success or otherwise in facilitating voting,
yes,
or in encouraging voting.
These aren't in my submission oppositions. These are cumulative. They're not in opposition to each other.
So, or is to be read as meaning and, is it?
Yes.
Yeah.
That's right. Final thing, I will may have to take some time off my reply, in fairness to my learned friend. There's another clue is in paragraph C, which is, do the procedures provided for by the scheme lead to any increase in impersonation or other electoral offences? It doesn't say decrease. If Parliament was thinking about bringing in ID things aimed at reducing fraud, this wouldn't make sense. This is having exactly in mind what my Lord Sales had in mind about bringing in new procedures like computer voting. Is that going to increase a problem with personation? But you see, it says, do the procedures provided by the scheme lead to any increase? That envisages a procedure that will be different from just putting a cross on a ballot paper. The procedures provided for by this scheme are merely procedures to provide ID. Now, how could that increase personation? It doesn't make sense if a scheme of this sort is envisaged by the Act.
But, well, it may just be that the report on this scheme says, no, it didn't lead to an increase in impersonation.
Lord, no.
But, well, let me put this to you. Doesn't the fact that C is there show that the power itself, when it is exercised, very definitely is concerned with the risk of personation and with the question of proper verification of those who have the right to vote?
Definitely. My Lord, yes, if there is a change in the law about how you vote, then you are concerned about whether that change in, whether the procedure provided for by the scheme here is talking about not bringing in ID, it's talking about changing the place or the time or the method of voting. You then have that is a new procedure. Then you ask yourself, has that led to an increase in fraud? It doesn't envisage the precise opposite, which is same procedure, no change there at all, but let's bring in an anti-fraud provision, because it doesn't envisage that at all. It envisages the opposite. Now, these are points for purpose laws, in the sense that when we're trying to gather the purpose of a section, it's unlikely things are going to be all 100% clear unless the statutory purpose is spelled out. But here, all of this put together, my lords, surely indicates the purpose is the way in which Mr. Coughlan puts it. These are all... And the final point, because I've gone over my time, is this. Looking at this section, what words in this section warned any MP or any of us that the minister might get the power to bring in, not change anything about the elections at all, other than to bring in these onerous requirements for some people of documentary ID, and give that power to the officer on the desk to exclude you uncontrollably on a reasonable doubt, something that hasn't been allowed for 150 years. And my submission is nothing. Nothing gives you that clarity of language or gives one the reassurance that this has gone unmissed in the democratic process. This hasn't spelt out to Parliament what this meant anywhere. And before I sit down, my Lord, nowhere does the Crown in their response do they deal with, in any of their written submissions, about the problem of all of our rights to vote being subjected in these pilots to the subjective judgment of the unqualified officer on the desk, of the Mississippi at its worst point, so to speak. There's nothing there at all. Lord, I'm sorry I've gone over time. If I can assist further.
No, not at all. Thank you very much, Mr. Peter. Mr. Avanetti.
My Lords, you'll have seen from the statement of facts and issues that we say the appeal turns on two questions of statutory construction. Firstly, were the pilot schemes within the meaning of section 10.2a? And secondly, were those schemes authorised for a lawful purpose under section 10.1? That's EF 78, Statement of Facts and Issues. I propose to make my submissions by reference to those two questions, but I hope that in addressing them, I'll answer the 4 issues identified by the appellants. Before I turn to those 2 specific provisions, could I address a point raised by my Lord Sales near the beginning of my learned friend's submissions? What is the purpose of these provisions overall? We say the purpose of section 10 is to enable the gathering of information or an evidence base to assist in the assessment of what measures should be taken forward under section 11. The purpose of specific pilots may be to increase voter turnout, but section 10 is not limited in that way, although of course we accept that that was one of the concerns that formed the prompt for the introduction of this legislation. In terms of the purpose of these provisions in context, we say that the Court of Appeal accurately identified it at EF 241. It's paragraph 51 of the Court of Appeal judgment, part of the judgment of Lord Justice McComb. Paragraph 51, what is provided for by section 10.2 is pilot schemes. Such schemes will naturally have advantages and disadvantages. The pilot enables such things to be assessed to see whether the schemes in question deserve further consideration or should be avoided. They're confined to particular elections for the purpose of informing decision makers for the future. Not necessarily likely to have absolute success in the particular elections which they're first trialled, but that's what's provided for. Schemes for the purpose of informing decision makers for the future. Against that background, we say that a scheme providing for a procedure for demonstrating an entitled to vote at the polling station is a scheme within section 10.2a. That interpretation is consistent with the language used. Could we turn up section 10 again? You may have it to hand because my friend finished with it, but it's at pages EF number 1690 to 1692 in volume 1 of the authorities. I'm sorry, could I just move slightly? I think I'm not being picked up very well by the microphones. Not at all, it's my fault. Thank you very much. Thank you. So, looking first at the opening words of section 10.2, a scheme under this section is a scheme which makes, in relation to local government elections in the area of a relevant local authority, provision differing in any respect from that made under or by virtue of the Representation of the People Act. Parliament could have narrowed that down, but it didn't. As regards one or more of the following, namely when, where and how voting at the elections is to take place. There again, Parliament could have adopted alternative language, narrowing the scope of A. For example, it could have referred to how votes are to be cast, which is the language it used in 10.2b. But it didn't. The language is wide and permissive, and we say that's consistent with the intention to provide a piloting power for the purposes of information gathering going forward. Of course, with the overall ultimate aim of improving voting procedures. Secondly, we say that a wider interpretation is necessary to enable viable pilots and to avoid anomalies. And here it's very important that it's common ground that the language of section 10.2a extends to schemes providing for remote voting arrangements. And these necessarily require disapplying the existing procedures for demonstrating an entitlement to vote and introducing new procedures. And we've looked briefly at the current procedures. They include, at EF page number 1940, the number and name of the elector being called out. Obviously can't be done if you're going to have remote electronic voting.
Oh, I'm sorry, can you give me the page number again?
Sorry, my lord.
No, it's my fault.
EF 1940.
Thank you.
And it's Rule 35(1)A of the current rules. And as my learned friend quite rightly says, these rules, broadly in the same form, have been in place for some 150 years, calling out the name of the elector may have been a valuable, effective safeguard 150 years ago, when perhaps people didn't have photographic identity and when one might imagine that people would be more likely to be known to each other. But it certainly couldn't be used now if any of the modernisation procedures envisaged, like electronic voting or telephone voting, were carried forward. And we see by 35(2) that in the case of an elector who has an anonymous entry, he must already, under the current procedures, show the presiding officer his official poll card. At Rule 33, EF 1939, we have the list of questions that may be put to voters. Which include, are you the person registered? Read out the entry. Have you already voted here or elsewhere? And 5 on EF 1940, where a person applies, this is number 5, question number 5, when a person applies as an elector in relation to whom there's an entry in the postal voters list, did you apply to vote by post? Why have you not voted by post? And Regulation 33(3), a ballot paper must not be delivered to any person required to answer any of the above questions unless he has answered each question satisfactorily. So they already include an element of subjective judgment, as they must do. But the key point is that you cannot trial electronic telephone voting without changing the procedures for voter identification. And the appellant's answer to that is that, well, that requirement's ancillary to the purpose of the scheme. The purpose has got to be to increase voter turnout, encourage voting. But at the stage of 10.2a, that's irrelevant. Purpose is relevant when we come to look at 10.1, the purpose for which the power is exercised. For the purpose of construing section 10.2a, the purpose of the scheme is not relevant. Either the changes made fall within the meaning of 10.2a, or they don't.
I think they say it has to be ancillary to a when, where, or how change.
Yes.
You can't have a freestanding change to...
Well, it's got to be within when, where, or how, in reality, if it's going to come within 10.2a. And we say that looking at those words together, when, where, or how, it's quite a broad formulation, and it's intended to cover the procedures for voting at the polling station, or if you're voting remotely at those elections, which include the identification procedures. The broader statutory context indicates that 10.2a should not be construed narrowly. It's got to enable useful experiments, to enable proposals for reform to be made on an informed basis. That is the purpose of this legislation. And there would be very surprising consequences if Malone and Friends' analysis was correct, the ancillary to. Because, say, for example, you had a pilot which was expressly designed to improve voter turnout, and it seemed to be successful in doing that. It was taken forward and introduced into legislation, and then it became apparent that in practice it was giving rise to problems of personation. There wouldn't be any power to pilot different voter identification requirements to address that problem that had arisen. They wouldn't be ancillary to a different purpose in the pilot scheme. That pilot scheme would be foursquare directed to more effective voter identification. We say the appellant doesn't identify a satisfactory alternative positive case. The formulations they've identified, manner or means by which electors cast their vote, or the technical modalities of voting, are not the language that Parliament has chosen to use. And we say they're broad enough to encompass these pilots anyway. There are other arguments raised by the appellant in their written case which weren't developed in oral submissions, such as the justum generis principle. We've addressed that in our written case by reference to the Broutsea Haven case. This isn't a situation where you've got particular words followed by general ones and the principle simply isn't engaged. Similarly, in our written case, EF 163, paragraphs 59 to 60, our interpretation doesn't render when and where OTOs, but it recognises that there isn't a sort of hermetic distinction between them. So, for example, if one looks at electronic or telephone voting, that'll engage where and how. It's probably no coincidence that they're all part of 10.2a. Parliament hasn't separated them out. A, when, B, where, C, how. It's a compendious formulation. So turning then to the principle of legality, if I may, we address this in our written case at some length, paragraphs 61 to 78, pages EF 164 to 170. But I'd like to develop some points in particular, if I may. Firstly, it is a principle, not a rigid rule. And it's intended to assist the court in statutory interpretation. The key aim is always the same. It's to identify the intention of Parliament. If I need authority for those propositions, we get them from AJK in the authorities at volume 4, and I wonder if we could very briefly turn that up. It's EF 2827, that's the part of the decision I want to take you to. The case itself starts at EF 2815. But at 2827 at paragraph 28, Lord Dyson makes the point that I've just made. The principle of legality is an important tool of statutory interpretation, but it is no more than that. When an issue of statutory interpretation arises, ultimately the question for the court is always to decide what Parliament intended. And the rationale for the principle is important, and we can look at that by reference to two dicta of Lord Hoffman, which are helpfully both set out in this case. First of all, in the Morgan-Grenfell case, which is summarised at paragraph 24, Lord Hoffman addressed principle of legality, paragraph 8 of the Morgan-Grenfell case, which is set out at paragraph 25 of AKJ. He said that the courts would construe general words in a statute, although literally capable of having some startling or unreasonable consequence, such as overriding fundamental human rights, as not having been intended to do so. And that is, in my respectful submission, quite a good check. Is the consequence of giving the words their ordinary and natural meaning a startling, unexpected, unreasonable one? Because the court think it would be very, very surprising if this was what Parliament intended. And then at paragraph 27 of AKJ, towards the bottom half of the page, there's the citation of the famous passage from Ex parte Sims. The principle of legality means that Parliament must squarely confront what it's doing and accept the political cost. Fundamental rights cannot be overridden by general or ambiguous words. That's because there's too great a risk that the full implications of their unqualified meaning may have passed unnoticed in the democratic process. In respect of that, we say it's quite clear that Parliament knew what it was doing in enacting Section 10. It was actually protecting the right to vote in local government elections and the right to vote more generally by introducing a very careful sui generis scheme so that the consequence of changes wouldn't just be judged by speculation or by extrapolating from different elections in different contexts in different jurisdictions. It would have practical information, sometimes from repeated pilots, because this is the second lot of pilots about voter identification. Where the changes can be calibrated and you can look at the different effects of making one change or a slightly different change. And I'm so sorry, it's just been drawn to my attention that I've gone 2 minutes past 1 o'clock. Should I stop there?
Yes, we'll adjourn and resume at 2 o'clock.
Thank you very much.